Settlement agreements, AB 749. Well, what the legislature did is it says those provisions, no rehire provisions, are now invalid. An agreement to settle an employment dispute shall not contain a provision preventing or otherwise restricting a settling party from future employment with the employer, a parent company, a subsidiary, a division, an affiliate, or a contractor of the employer. Now, employment disputes includes not only lawsuits, it includes administrative claims like the DFEH. It includes ADR like arbitration proceedings. It includes internal grievance proceedings. Almost anything where an employee actually has a dispute and you enter into a settlement with them, you cannot put a no hire provision in there. There are two exceptions, which seem fairly obvious. You can have a no rehire provision if you have a reasonable grounds to think that the employee committed sexual harassment, good reason to terminate them. And if you have good reason to terminate them, that's well documented. And so that they're kind of almost the same reason. So unless you have that, any other provision is going to be void and of no effect. Other documentation issues. I just want to talk about non-compete provisions. Everybody, I think, pretty much knows that under the Business Professions Codes, non-compete provisions are really problematic. There was an interesting case this year because it was a Delaware company that had offices in California, and they had a non-compete provision for their California employees that said it's governed by Delaware law. And eventually ended up being litigated in the Delaware court. The Delaware court said, yeah, we know it's governed by Delaware law, which allows non-competes, but California's public policy is so strong that we're going to recognize California's public policy and we're going to invalidate this non-compete provision. So in general, non-competes are not going to be enforceable. Non-solicitation provisions. This is a change in the law. For a number of years now, since the mid-'80s, the law has been that non-solicitation, that's where you say to an ex-employee, when you leave, you can't come solicit my employees to leave their employment and go work for you. Since the mid-'80s, the law in California, case law has been, that's a valid provision because you're not really restricting the employee from leaving you. All you're doing is restricting that you're allowing them to be contacted by a former employee. At the end of 2018, there was a case decided which rejected that prior law and held that non-solicitation provisions are also unenforceable. And this year, there was a federal court decision that followed that state court decision and analyzed it and basically said, do we think this is the more logical approach? And basically held that non-solicitation provisions are unenforceable as well.